Good afternoon. Attorney Protective would like to welcome you to today's webinar, Scary Good Tips for Identifying Potential Legal Malpractice Exposure. Please reference your materials for information about today's speakers, Seth Laver and Matt Marrone. With that, I would like to introduce your first speaker, Seth.
Thanks, Kate, and thank you, Attorney Protective. Matt and I are always happy to be here, and we enjoy this presentation. I think this is our sixth or so. I can't believe that. We're, like I said, happy to be here. And thank you to our audience for joining us. Our goal is to make this about an hour well spent. Matt and I are going to cover some traps facing attorneys. The risks are hidden and often aren't totally unexpected if you know where to look. The truth is, it's impossible to instruct everyone how to prevent malpractice claims. You can't prevent them, but you can help to avoid them. That's our goal. As our title suggests, we want to help identify the potential exposures. Let's take a look at our agenda. We're going to throw some numbers at you which prove that claims against lawyers are still on the rise. And a quick spoiler alert, it's at an all-time high. Next, we'll cover who are the typical plaintiffs, what the liability theories are. We'll discuss the beginning and end of an attorney-client relationship. It's almost impossible to discuss malpractice without covering conflicts, so we'll do that. We'll talk about the problem client, and then we'll conclude with some takeaways. Finally, if there's time, and I hope there is, we'll conclude with a Q&A. Okay, so let's dig into the numbers a little bit. And before we do that, I just want to give you an idea of where these numbers come from. There are insurers and consultants, they're really brokers, I guess, who compile legal malpractice trends every few years. Most of our data comes from this terrific report that surveys malpractice insurers. The most recent update from May of this past year was the second publication since the end of COVID. So we're going to start with the bad news. Number of claims is off the charts. We're at an all-time high, and the severity of those claims is rising too. Malpractice claim frequency peaked in 2019, it tailed off a bit, and then it surpassed it last year. In fact, more suits was the trend since 2011. It started to slow down a bit, and then it just jumped up again. More bad news is that the exposure and cost of defending those suits is higher than it's ever been, meaning our mistakes are more expensive today than in the past. We also know that many claims settle before they even hit suit, so these numbers may not reflect those allegations that don't hit the docket. So why are we pushing all this bad news your way? It's because the data is helpful. It helps to focus on the question of why these numbers are rising. And if we can get our head around the why, it helps to reduce those risks in your practice. All right, so let's take a look at what you see on your screen. First, there's more lawyers today than ever in history. It's about 1.5 million lawyers in the U.S. On average, about 200,000 more lawyers each year since 2008. And those numbers, perhaps as you would expect, are starting to trail a little bit. But attorneys are living longer and we're retiring later. What does that mean? It means there's more lawyers to sue. It also means more competition. And while competition can be a positive drive and a motivator, there's clear downsides also. There's more reason to overpromise or overextend, to keep or maintain a client relationship. There's more reason to set unrealistic expectations, to dabble outside your comfort zone. And what is dabbling? Dabbling is when we take on work that we just don't know how to do. And that's a terrific way to find yourself in the crosshairs. Next, you'll see insurance, and we could talk about how while claims are rising, insurance is rising also, which means a larger target. And while insurance is an all-important risk management tool, it's also a driving factor in seeing more claims. Matt, you're up. What do you want to touch on?
Excuse me. Hi, everybody. Thank you, Attorney Protective, for inviting us back again this year. It is hard to believe we've been doing this for so long, Seth. And also, special thanks to Ames and Guff, which is the insurance broker who compiles this survey and publishes it every year. By way of brief explanation, what Ames and Guff does is they survey their insurers that they work with, and we're talking about large insurers. So these are so what's interesting is these statistics are really reflective of large law firm claims, and I can tell you, and I think anybody would tell you that I don't know who our audience is. I suspect we probably have a mix of people from some small firms, some solos, maybe some large firms as well. But the claim frequency among small law firms and solo practitioners is even higher than it is with large law firms. So yeah, the claims are up. It's just there's just been no let up over the last 6 or so years that we've been doing this presentation, and if you look at these numbers, they just keep going up. I think that personally, I feel like lawyers are being held to higher standards. I mean, yes, there's the standard of care, and there's case law in different jurisdictions that can kind of help, that can help inform what the standard of care is. But what it really comes down to, in my opinion, is that lawyers, whenever there's a bad outcome for a client in anything, whether it's a transactional matter, whether it's litigation, whether it's a business deal, whatever it is, if a lawyer's involved and the client gets a bad outcome, they are just more and more likely to file malpractice suits. That absolutely has been our experience. It's what we've been seeing over the last 10 to 20 years, but more recently in the last, probably 5 to 10 years. Seth and I, we subscribe to all kinds of industry publications. We get, email newsletters delivered to us every day about this kind of stuff. And it's just every day you're seeing, the headlines of these newsletters are malpractice claims, and they're big ones. If they're, if it's a big firm and it's a big policy and it was a big transaction issue, those are the real big ones. But if it's smaller, they can still be, 7 figures for sure. So I think that certainly the complexity of practices has something to do with it. And again, I think sort of this concept of higher consumer expectations, that if a lawyer's involved and there's a bad outcome, it's almost like the lawyer is viewed as a guarantor for whatever happened. And that's not the law. The law in every jurisdiction that I'm aware of says that a lawyer is not a guarantor of an outcome, but and that is still the law, but it's just in terms of claims being filed and kind of the expectation or the, what's driving the claims is, I think that's what it is. And insurance plays into that too. Everybody knows there's insurance out there now, and it kind of, it's kind of just a cost of doing business, as I say to all of the lawyers that we represent, look, there's to try to make people feel better, look, there's 2 kinds of lawyers out there. There's lawyers who have been sued, and there's lawyers who have not been sued yet. And I say it jokingly, but there is some truth to it. So, and if we look, if we kind of flip, I see the next slide is up there. The study continues, and this sort of it reflects that the trust and estates area of practice being the number 1 area of practice for claims. That's relatively, that's a relatively new development. I mean, we're we're embarking, the baby boomers are aging, we're embarking on a period of what's going to be the greatest transfer of wealth probably in history, and that's going to be happening over, I'd say, maybe the next 30 years. And the amount of trust and estate related malpractice claims that we're defending, they just keep going up and up and up. I mean, I'd say probably 5 years ago, I'm not sure that I had one. Now it's probably half of what I'm doing. And they could take so many different so many different shapes and forms and everything. So that's not going away. It's only going to keep increasing, which I'm sad to say because my wife is actually a trusted estates lawyer. But then we look at business transactions, corporate securities, real estate, all of these things where there's really transactional areas of the law, not so much litigation. It used to be that personal injury plaintiff lawyers were the ones who got sued the most. Not anymore. And even on the insurance defense side, I would say, it's becoming increasingly common. For instance, if an insurance carrier retains defense counsel to defend a matter and there's a bad result at trial, insurance defense carriers are now suing their own defense counsel, for malpractice. That's happening with greater frequency, and it's almost like they're using it as a risk transfer mechanism. It's one insurance carrier trying to, push off, the bad result to the malpractice insurance carrier. So, so it's just, all of this is factoring into it. It's just getting, really getting, it's just going to keep increasing. I'm sorry to say, but that's so I don't know. Seth, do you have anything else to add on this slide?
Yeah. Thanks, Matt. What I was thinking about was the common thread between trusts and estates and business and commercial. What do they have in common? And I think, Matt, you hit it nicely, but I'll just add that both of those practice areas have a level of hand-holding and trust. There's some vulnerability there. It's more emotional for whatever reason, where clients may feel less satisfied in an estate or transactional matter. Also, both have a ton of conflict issues, so perhaps that's why those two items are at the top of the list. And then I just want to highlight a point that we'll get to later, is that collection suits is, where does that fall? That's in that table as well. And I looked into this but couldn't find any specific data, but it seems that any time a client sues for unpaid fees, they're countersued. So collection suits are risky, and we'll talk about that down the line. Okay, let's take a look at the next slide, please. And this is the most frequent allegations against attorneys according to the survey that we're referring to. Conflicts. Those are reportedly the highest by magnitude, like 2 to 3x. And the risks of conflicts are growing as firms expand through mergers. And we're going to talk about mergers in a minute, but it would appear that firms just don't have competent safeguards in place to detect conflicts. So those remain a problem. What else? Failure to calendar, failure to file timely, clerical errors. These are preventable, sure, but they could also just be bad luck. So our hope is that if you know of these risks, you hopefully could avoid them in your own practice. Okay, next slide.
Hey, real quick, Seth. The one thing I'll mention on that, on the conflicts of interest, again, keep in mind that this survey, again, was a survey of large law firm insurers. So with large firms, you got more people, more departments, and more potential for conflicts, which I think is why that pops up as number one on this survey. That's not to say that with small firms, conflicts still aren't a thing. They certainly are, but it's not just, when we talk about conflicts of interest, it's not, it's, well, you know what? We're going to get to that later, so I'll pause there and address it a little bit. So, thanks.
That was a nice little teaser. Okay, so we know that the cost of defending suits, we know that the claims are rising, but also the cost of defenses as well. The exposure is apparently the highest in history, according to the survey. There are more $500,000 reserves set for legal malpractice claims than ever before. Since the claims are larger, as a result, the cost of defense is higher. And also the attorney's fee, our fee to defend those claims is rising. And take my word for it, these rates aren't huge, but they're naturally increasing over time, which contributes to larger exposure or larger budget. And all of this has the attention of carriers. In the survey over the past couple of years, the carriers also included some other concerns that they have, and that's reflected on the next slide. Matt, do you want to take a crack at silent cyber first?
Sure. And also just for people listening too, I'm sitting here watching all the questions being put in the question box, and there's a ton of good ones. Unfortunately, and they just keep coming in here. Just so everybody knows, I mean, we've got roughly, I think, 2,000 people on this presentation right now. So obviously, we're not going to be able to address questions as they're coming up. We'll try to address some of them at the end, but I just wanted you to know that I am looking at them, and this is one of my problems, because I start getting distracted looking at these questions and wanting to answer each one of them instead of focusing on the presentation. So, to talk about cyber for a little bit, I mean, we're seeing cyber issues blend into malpractice claims now. In particular, business email compromise, where the lawyer, where somebody hacks into the lawyer's email and basically maybe tells somebody else, gives fraudulent wiring instructions. Like for instance, let's say I'm representing a client in a business deal, and I'm negotiating with the other side, and we're getting close to the closing of the business deal, and it's getting to the point where we have to start wiring money, either the client to me or the client to somebody else, and unknowingly somebody has hacked into my email system and is monitoring all of this stuff happening, just lurking in the background, monitoring what's happening, and then when the time is right, inserts themselves into the email chain, provides fraudulent wiring instructions, and the money gets wired to somewhere it shouldn't be, and it's gone. We are seeing that happen a lot. And what I want to say to you all, a few quick points on this. First of all, don't ever wire money to somebody else without first calling them to confirm, independently calling a number to confirm the wiring instructions. Tell your clients the same thing. If you've got an IT person or IT department, if you don't have multi-factor authentication, please look into that. What that does is it just makes it much harder for fraudsters to tap into your email system. So talk to your IT folks about multi-factor authentication. That can help prevent your system from being hacked. Talk to your insurance broker about whether you have cyber insurance. You need to consider that. Some legal malpractice insurance policies will have a sublimit or some kind of a component of cyber insurance on it. Trust me when I tell you that all the policies are different. There is no standardized cyber insurance coverage out there. So that quote unquote cyber coverage is not going to be the same. So understand, what it does provide, what the coverage provides, what it protects you for, and what it doesn't protect you for. So just these are all things that talk to your IT folks, talk to your insurance broker about these issues, because it's an area of exposure for you. That's not sort of a traditional. It's not malpractice, right? If your system gets hacked and funds get wired somewhere different, that isn't really malpractice, but it does involve sort of, it's going. You can get sued for it. So anyway, that's I think probably all I need to say on the cyber piece of things here.
Great, and I'll jump in and hit the first bullet point, which is lateral hires. And I think I alluded to this earlier, but lateral hiring, this was astonishing to me, is up 45% since 2019. And reportedly about half of those moves fail, and 35%, more than a third of malpractice claims involve lateral hire. which is about 8 times larger of a risk than for sitting incumbent attorneys. I don't know if these folks aren't comfortable in their new gig, if they're not complying with internal risk management tools, they're less due diligent. Whatever the reason, lateral hires causes claims at an alarming rate. All right, so we've talked about these real risks and what's concerning insurers. Now we're going to turn the page and talk a bit about the potential plaintiff and who's suing attorneys, and Matt will take the lead with that.
I mean, historically, this is a big area or a big reason why claims have increased. I mean, traditionally, attorney has an attorney-client relationship with the client, and the client is the only person that can sue the attorney because that's the privity of the relationship. And that's still largely what we see, but it's not the only thing. We see people from outside of the relationship now filing claims against the lawyer, and the law is going to vary from state to state on whether or not that can be done or what the restrictions or limitations are. But some states are pretty stinking liberal when it comes to not to get involved in political stuff here, but liberal in terms of the construction of who is allowed to assert claims against a lawyer. You could end up facing claims from people outside of the relationship, especially in the trust and estates, aspect. I mean, beneficiaries to the will, claims by, beneficiaries of a trust, if the trust wasn't administered, properly. And then sometimes just claims from people that weren't even your client that said, maybe they thought they were your client. Maybe they're saying, you were my lawyer, and you're saying, no, I wasn't. You can't sue me. But you're still getting sued. I mean, we've handled, tons of those. And you're then fighting about, that you weren't even the client. That this person had no reason to believe, that they were even the client. But, so, that's, the class of people, that are able to sue you, continues to grow. I mean, we're not seeing any states, dial it back. I mean, it's not like, it's not like states are taking a more restrictive approach necessarily. Maybe some are, but generally speaking, courts, it's frustrating, but a lot of times judges and courts just don't seem to like lawyers very much, which is, the irony there is kind of rich. But, and again, of course, it depends on the state, but that's kind of where we are. And if we go to the next slide here, we've got expanding, theories of liability. The traditional cases are just the negligence, malpractice, or a breach of contract theory, which, incidentally enough, like sometimes, like in Pennsylvania, for instance, they have different statutes of limitations. So, like a malpractice statute might be 2 years, but a breach of contract is 4 years. And so it's almost like the statute of limitation can effectively be enlarged because depending on what kind of claim is being asserted. Misrepresentation, that's certainly that's a claim that we often see asserted by non-clients, that the lawyer misrepresented something to somebody and now they're being sued for it. Breach of fiduciary duty, that's largely the same as malpractice. And then you've got fraud and conspiracy, which we don't see a lot of, mostly because insurance policies don't typically cover fraud, and smart plaintiffs lawyers know that, so they're not going to assert a claim that is going to not be covered by the lawyer's insurance carrier for the most part, but we still do see some, especially in some of the nasty ones. But so that's, those are, I guess, probably painting in broad strokes here the kinds of people that can sue and the kind of claims that they can assert.
Thanks, Matt. And I'll just point out that I'm defending an attorney in a fraud claim from a non-client right now. and it's nasty, and it does happen. All right, so on the next slide, we'll talk about how to evaluate attorney conduct, and there are several standards that apply. We'll start with the standard of care in each jurisdiction, and usually that standard is what would a reasonable attorney in the area have done in this scenario, and that's often the first place to look. There's also guidance from the RPCs, the Rules of Professional Conduct, which may be different in each jurisdiction, as well as the model rules. Now, in terms of the Rules of Professional Conduct, those are a guide in that a breach of the Rules of Professional Conduct does not automatically equate to a breach of the standard of care, but it could be evidence of negligent conduct. Then, along the hierarchy, we see cases applying the law to attorneys, cases applying the law to other professionals, and then finally, state regulations to evaluate attorney conduct. The standard of care holds the most water, followed by case law, and then finally the state regulations. All right, so if I have my notes straight, I think, Matt, you'll now kick it off with the lifespan of the attorney-client relationship, when that relationship begins.
Yeah, I mean, there's the slide. I mean, I think this really relates, Seth. This is going to kind of blend into our discussion about engagement letters and disengagement letters, which are the important parts here. But that's here. I mean, how the attorney-client relationship formed. It can be specific, where client signs an engagement letter, and the engagement letter says what you're going to do and spells out what your rates are going to be and all of that. But that isn't necessary, I mean, an attorney-client relationship can also just be formed if somebody starts talking to you and you sort of agree to maybe start doing some stuff, for them, and all of a sudden, it's like, even though they haven't given you a retainer, even though they haven't paid you, even though that there's been no letter signed, arguably from that client, or I think the term is putative client, from the putative client's perspective, they might think that you're now their lawyer. And that's, and you can get, and so if something goes wrong, you can, I mean, we've seen lawyers get sued over that kind of stuff, where, sort of that third bullet point on the first section there, where the lawyer fails to manifest lack of consent, where you don't specifically tell somebody, look, I'm not representing you yet. I'm not representing you for this. So, and we'll get into that more in a minute in terms of risk management advice, and then it ends, when the matter is concluded. But the point is that, if you're not careful, if you don't specifically tell people what you're doing or what you're not doing, you can get yourself in a jam.
Yeah, Matt, you're spot on in that.
Oh, yeah.
It's the gray area. We're not talking about kind of the formal engagement, right? That's the easy part. It's what about, you'll see on the next slide, what about, the casual advice, or, the failure to limit the scope of your engagement. And the four on your screen are problem areas. We'll start with casual legal advice, which I think is also the next slide, is it not?
Yeah.
There you go. Yep. Right. So what is casual or informal advice? Now, Matt and I were speaking about this about an hour ago, and we just want to point out that while this is an important risk management tool, neither of us have seen a malpractice claim arising from this sort of informal advice. Still, we want to make sure we point it out for you. What is casual informal advice? It's your friends, it's your relatives. I've made this joke before. It's Uber drivers. Every Uber driver I've ever had has asked me for legal advice. And it's usually harmless, but it's also risky. I mean, what happens if they rely upon your casual advice to their detriment? What if they believe that you're their lawyer, and they don't actually have one? They rely on whatever you said and something goes wrong. It's the casual conversation that the client takes seriously. Again, this might not necessarily lead to claims, but it's a really important tool for you to consider. What about a casual referral? What if that goes terribly? What about a casual suggestion that results in a blown statute? Again, there's no engagement letter. You're not being paid for this, but there's still real danger.
And that's what we were talking about, Seth. Was I think where it can happen is if you already have a client, right, that maybe you're, whatever, that you're handling a real estate transaction for them, or maybe you're drafting a will for them or something, and then they start asking you other stuff, outside of, well, my my sister's going through a divorce, and she's dealing with alimony or whatever, and what do you think about that? And it's just kind of you just have to so the Uber driver example is funny, but I think the more just when you have existing clients already that you're representing them for, like don't you want to be helpful. We all get that. You want to be helpful, and I think some of this is to scare you all, perhaps more than we need to, but maybe not. So just be careful about what it is you start telling people.
Yeah, that's right. And another way that we need to be careful is with respect to online advice using the interwebs. I'm sure we all do this to some degree. Maybe we use legal blogs, maybe social media for marketing purposes. And I'm certain that you've all heard this before, but you have to be really careful when you do this. What we're doing effectively is we're providing legal advice anonymously in cyberspace. We need to market ethically online. We need to include disclaimers. We absolutely should avoid chat rooms. But you need to be very wary of online advice. And Matt alluded to this earlier, as did one of our slides, but I want to talk about disengagement letters and declination letters. We know, or we talked about how to define the beginning of the relationship, but you also need to talk about how to define the end of it. A disengagement letter is just the perfect tool to clearly define the end of the relationship. Maybe the case is over, or the transaction is over, or you have a difference of opinion with the client. That's the time to start thinking about disengaging. What if the client stops cooperating or communicating? That's when you want to think about a disengagement letter. Along those lines, a non-engagement letter, or some people call them a declination letter, that's also helpful. And in a few slides, you'll see a sample that we put together. But this is the letter to ensure a potential client, or even a current client, that you are not expanding the scope of the relationship. I'll say that differently. So for a potential client, you're saying thanks but no thanks. Or for an existing client, you're saying I will not expand the relationship to include that proposed task. We're talking about the scope of the engagement, and you want to have brackets on and specifically define what it is that you're hired to do and what it is that is outside of that scope. So that's very important. And the next couple of slides talk about scope, and I think, Matt, you're gonna touch on those.
Yeah, you got that one that's up there right now. Leave that up. I mean, it's it's unfortunately, I mean, we have to try to cover our butts as best we can. I mean, and an engagement letter, a disengagement letter, all of that helps us do that. So in an engagement letter, we're identifying who it is that we're representing. We're identifying who we're not representing. So that, look, we're representing you. That doesn't mean that your family members are being represented by extension, or what's the scope of the engagement, what it is that we're going to do, and what are we not going to do. For instance, if I'm representing a client in litigation, and I tell them this in my letter, I will be defending you in this litigation, but it's not my responsibility to tell you to maybe go out and investigate any other insurance that you might have that might respond to this claim. I've seen lawyers get sued over that, where they're hired to defend somebody, and then all of a sudden, somewhere down the line, the client finds out that they had insurance that actually might have helped to protect them, and And now the insurance carrier is declining coverage because they didn't get, prompt notice of the claim, and then the lawyer gets sued because, you didn't tell me to, report this to my insurance carrier. Well, that's not my job, and I'm telling you at the outset, that's not my job. That's just one example. Remaining aware, during the scope of the representation, if you start to get a sense from somebody, from your client, that that maybe now all of a sudden a husband or a wife or a sibling is involved in the relationship here, disabusing those people of the fact that, hey, listen, you're not my client. I'm not going to be communicating with you about this stuff. Or if the client thinks that maybe wants you to has different expectations about what you should be doing than what you are, sending him an email, or you don't want to. Again, it's the more you can cover yourself, the better you are. And the better the client will be too, because then the client knows, is clearly notified as to what it is you're doing or not doing. I think down the next page we've got, clauses that are in the engagement letter. I know there's this you'll see it in a couple slides. There's a sample engagement letter we have here. But what I'll also mention too is that a lot of times there are insurance benefits for having engagement letters. I'm willing to bet that your malpractice carriers probably ask you if you use them, and hopefully I'm sure you're answering that truthfully, one way or another. But we've seen a lot of carriers now, or at least some carriers, that if the lawyer, let's say you've got like a $10,000 deductible on your policy and you get sued for malpractice, there are some insurance carriers out there, I don't know if Attorney Protective is one, they might be, where if you're getting sued on a matter where you had an engagement letter in place, they might give you a break on your deductible, because it's their way of saying, look, we appreciate that you're trying to do the right thing here. So, just another kind of side practical benefit. And these letters can be, extremely useful tools in the litigation process. So, if there's a few points, there's a couple of points that I personally want you all to take away from this today. And one is to please use engagement letters and non-engagement or disengagement letters as much as you can. And I think, I don't know, Seth, is it back over to you at this point?
Yeah, thanks, Matt. So let's just drill in a little bit on some engagement, the importance of engagement letters and consistency with other factors. And I'll explain what I mean. We talked about everything done by professionals is defined by this contract, right? The contract is all important. And it applies to all professionals. In accounting, bookkeepers are not auditors. Dentists aren't plastic surgeons. You get the point. Clients engage professionals to perform defined, specific tasks. And then if something were to go wrong, the professional is judged based on what he was hired to do. So it's essential, as Matt just said, that we have these clear engagement terms in order to manage expectations. After a lawsuit, after it hits the fan, we look to the engagement letter to define the roles and expectations of both parties, right? Because this is the contract. But from there, it gets a little cloudy, because what about your billing records? Do the invoices match the client's expectations? In other words, were you billing for work that maybe fell outside of your limited scope? That's a problem, and that would be, it wouldn't be a smoking gun, but that potentially could very much help a plaintiff when you're attempting to limit the scope and claim that your scope is limited, but your billing narratives suggest otherwise. What about your website? Have you marketed yourself to perform as an expert, and don't use that word, but as to have proficiency in an area that is outside the scope of what you're claiming in a particular dispute? How do you advertise yourself? What representations have you made? After the fact, the plaintiff is going to pick up your bills, they're going to pick up your website, and they'll use it against you if they can. And we'll be looking at them with kind of a different lens once a lawsuit's been filed. All right, if you don't mind, just quickly, I want to go through some of those clauses to consider. I think it's 2 slides back, maybe 3. There it is, thank you. So you want to think about who owns the file, and this could vary by jurisdiction, and it may depend on the circumstances, but ownership of the file isn't often an issue, but when it is, it can be a big issue, and it only becomes a problem if something goes awry. So get ahead of it in your engagement letter by perhaps documenting who owns the file and to what extent. Also define how the client should address fee disputes, how and when the client should raise any issue or question, how to resolve those disputes. That should all be defined in the contract. Mediation clause is a terrific term to include. I think we all know the benefits of mediation. There's an incredible cost-saving potential there. Theoretically, if it's a pre-suit mediation clause, you could avoid suit altogether. Now, I want to make clear here that there are courts and jurisdictions that have concluded that mandatory arbitration clauses, not a mediation clause, but an arbitration clause, those are unenforceable in the attorney-client context, but mediation clauses, you should be okay. And then you see stop work clauses. That's another risk management tool to consider in the off chance that, for whatever reason, the client stops paying you. And this is just a way to protect yourself. All right, so I think you already saw a preview of the next couple slides regarding engagement letter tips, and hopefully you've jotted some of those down. And then next you'll see some samples for you to consider.
Conflicts, right? Okay. Do this kind of quick here. We think about conflicts of interest. I mean, they don't come up probably in the sense that you're thinking of in terms of malpractice cases where a lawyer just failed to do a conflict check or is representing, God forbid, 2 opposing sides of a transaction. Obviously can't do that. It's more that you're representing a client, but then somebody else maybe thinks that you're also representing, maybe you're representing a business, right? And some of the shareholders think that you're also representing them, and something goes wrong with the business transaction, and suit gets filed over the whole thing, and then you're facing claims from perhaps some of the shareholders or officers or whatever about that there was a conflict of interest because they're alleging that you are representing all of them. I mean, that's kind of where we see conflicts popping up in these cases, and that those can typically be cured by outlining who it is you're representing, and if you get the sense that other people think you're representing them too, setting them straight that you're not. I mean, that's where we often see conflicts of interest, at least with regard to like small firms and solo practitioners. Again, with large firms, I mean, it's sort of the same situation where maybe a large business deal has gone bad, and then you've got one of the sides of it that maybe at some point in time, a long time ago, was represented by the law firm, and they're now alleging that maybe you had a conflict of interest, or the firm had a conflict of interest and never should have gotten involved, and that materially limited the representation. So, so those are, the 4 questions there. I think we've sort of touched on that. I mean, the point is that, you have to be, in order for it to be a conflict, you have to be materially limited in your representation. And then, can it be cured? I saw one question pop up in the box a while ago, asking about conflict waivers and, if those are good, if they can, sort of cure a conflict of interest. And The answer is maybe. I had a legal malpractice plaintiff's lawyer say to me once that that she that her best piece of evidence, if there's a conflict waiver letter in the law firm's file, that's her best piece of evidence because she can use it to prove that there actually was a conflict and that the lawyer knew about it and probably didn't explain it sufficiently to the client in the process of getting the waiver. So I thought that was kind of funny and also scary. But so, be aware of the rules. If there's ever a question in your mind, if you think, trust your spidey sense, be alert about, can I be representing this client? Can I be doing this? I mean, just read the rules, read the comments to the rules. I mean, those are your, read ethics opinions. If there's, sample, ethics opinions out there addressing those situations. I mean, just be aware of it. Use the engagement letters. What else was I going to say? Shoot, that escaped me. But that's the gist of it. And then if we go on to the next slide here, I want to. This is kind of the other important. If we go to the insurance consideration slide, Aaron. There we go. This is the other point that I want you, or it's going to be included in this, but I want you all to remember. So, malpractice insurance is important. Unfortunately, it is. And talk to, as far as a risk management piece of this, talk to your broker, like how much limits do you need, what kind of matters are you handling? Look at the size of the matters that you're handling, whether it's if you're handling big personal injury claims or big business deals, whatever, use that as a, what's on your worst day, what's the worst amount you're going to be sued for, use that as, as a guide in talking to your broker about how much coverage you need. Obviously, are you in a practice area that frequently generates claims? But then the most important thing here that I want you to know is malpractice insurance policies are what's called claims made and reported policies. It's not like an auto policy. An auto policy, for instance, is an occurrence policy. So if you're in an accident December 1st of 2021, right, your auto insurance policy that was in effect back then is going to cover you even if you're sued like 2 years later. That's not the way malpractice policies work. Malpractice policies work that they respond when the claim is made and reported to them, meaning that if you get notice of, if somebody sends you a letter saying, I'm going to sue you because you screwed up, whatever, that's the kind of thing that you need to send to your insurance carrier right away. Obviously, if you get sued, you need to send it right away. But even if you become aware of, a potential situation that later on could result in a malpractice lawsuit, you need to report that to the carrier right away. Because if you don't, later on, they can say, you didn't report this to us in a timely manner. You knew about this, a year or 2 years ago, but you didn't tell us back then. Now you've been sued, and we're not going to cover you because you didn't report this when you should have reported it. I can tell you that just in the last year, I've talked to probably, I think, at least 3 or 4 different lawyers where they've gotten themselves in this situation where they've been sued and the carrier has denied coverage because they knew the suit was coming or perhaps coming, a year or 2 ago and didn't tell the carrier about it, didn't report it. So that is you need to tell the carrier once you become aware of something that you think might lead to a claim. The policy language might obligate you to do that, and if not, when you renew your policy, you're probably asked on renewal, are you aware of any facts or circumstances that could lead to a claim? Because the carriers want to know that in terms of insuring you. So keep that in mind because the worst thing to happen, the worst thing that can happen is you've been paying for your policy, you got your policy in place, and then you get sued and the carrier says, we're not going to cover you because you knew about this and you didn't tell us. So that stinks. So So that's the please keep that in mind. All right, and so then on to the next slide here. This is probably this is not legal advice. This is not based on any standards. This is not based on any rules. But it's the advice that I most frequently give to lawyers, and it's where I see them most frequently getting sued, where they have just gotten themselves into a situation with a client who is a jerk, is the lawyer's trying to do them a favor, is trying to help, trying to accommodate them, or the lawyer gets involved in a situation where, they just shouldn't get involved. And I call it the problem client, right? And how do you identify that problem client? I mean, there's a list of things. I could probably add some more, but maybe they've already had a lawyer that they're complaining about, and now they're coming to you. Put the antennas up there. That they're demanding, they're not satisfied, that they think that they're doing you a favor by giving you their business, that they have unreasonable expectations about things, that you're always fighting with them, perhaps. Asks for favors, that sort of a thing. I mean, those are the people that are most likely to sue you later on if something goes bad. So, I mean, just be aware of people like that. Is it worth the business? Is it worth your time and effort to represent this person? Is it worth whatever fees they're going to pay you to deal with the headache and to deal with potentially a malpractice suit later on? It's a hard thing to say. I mean, you just have to trust your gut on that. And on the next slide, kind of related to that, Seth mentioned it later about suing clients for unpaid legal fees. I mean, I'm of the mindset that that lawyers, we do the work, we do a good job, we're entitled to be paid, and if a client doesn't pay, then you're entitled to sue them, and you are entitled to sue them. As Seth mentioned, a lot of times what that knee-jerk reaction will be is a countersuit for malpractice against you. Carriers don't like that. They probably don't like me giving you the advice that you should go ahead and sue people. But I just saw an article the other day, though, that more and more big firms are suing their clients for unpaid fees now because everybody's trying to maximize profits now, and fee collection suits have increased. I just saw recently. But what I would say to you is this, evaluate it. Like, is this how much money is at stake? How much is the client beating you for? How much do you think you can recover? Is it a lot of money? Is this a client that, if you sue them, they're likely to countersue? Is there a potential that a malpractice countersuit actually has some legs? Did you take a hard look at what you did or what the result was? I mean, is it, it's just, I would say to be selective, before suing a client for fees, be objective, perform a cold review of the file, talk to somebody. I mean, is it something that's worth doing? Just as on that last slide, is it worth representing this client? Well, here, is it worth actually suing this client for the fees they owe you? And what's the potential blowback going to be? So that's because Seth was right when he said it earlier. I mean, a lot of times if you sue, I mean, we see it a lot that suits for unpaid fees result in counterclaims for malpractice. So that doesn't mean you shouldn't do it. It just means that you need to be aware of it and think about it. Next slide, negative online reviews. I'm not really gonna. I'm gonna skip through that. I mean, I can't say that we ever had to deal with a lawyer being sued or even accused of unethical conduct because of this. Don't let yourself get dragged down in the mud. I would say, be careful about how you're dealing with clients and how you're, take the high road wherever you can. And then Seth, I think that gets us to our last slide here. If you want to wrap it up.
Yep, it does. It does. Thank you. I'll kind of hit this point. What we do for a living is hard. Practicing law is hard. We work to build our careers. We build our book. We work to develop a reputation and a specialty. Don't risk it. Don't risk all that goodwill and name recognition to be sued for overextending yourself or overpromising or dabbling. Practice what you know and don't stretch just to take on something that you're not comfortable with. Avoid the problem client and avoid conflicts. I've heard folks say that the most important decision an attorney makes over the lifespan of a case is deciding which cases to accept and those to reject. And I think that's sound advice. In engagement letters, that's how you're setting the tone. You're defining it's a contract. A good engagement letter helps to avoid lawsuits. But if you get sued, a good engagement letter is also the first line of defense. I would also add that you should take advantage of the risk management tools that are available to you, such as risk management hotlines. Perhaps your carrier manages one. Those are great tools to discuss disengagement, to discuss non-payment of legal fees, to discuss conflicts. If you have a question along those lines, get your carrier involved. I mean, they want to help you avoid claims. That's what they're there for. I just want to add, in terms of reporting claims, a claim doesn't necessarily have to have a capital C. A claim can also be, maybe you've been reported to the grievance committee. You may want to get your carrier involved there. What about a subpoena that you received? Your policy may include some sort of subpoena coverage or subpoena help. So it doesn't necessarily mean that a complaint has to land on your desk for you to get your carrier involved. I would urge
That's
you,
great advice,
to get those folks involved.
One more. Let me chime in on that. I'm glad you brought that up because I forgot to. Yes, if you get subpoenaed, like especially if you get subpoenaed for a deposition in something, don't handle that on your own. don't walk into that, cold or with a friend representing you. Tell your carrier because we've seen it many times where there's ongoing litigation. The lawyer gets subpoenaed for a deposition, walks in there and gets raked over the coals without the assistance of counsel, and then all of a sudden there's a malpractice suit coming out of it. So yes, if you get subpoenaed, if you get an ethics complaint against you, report those, because like Seth said, there's a good chance that your policy will cover assistance on some of that. And again, I can't stress it enough. If you get notice that you might be sued, tell your carrier. Get that coverage locked in. And then last point, in terms of practicing what you know and not dabbling, please don't dabble in trust and estate stuff, especially. It's so many lawyers do. Oh, my client just needs a simple will. It's just a form, or my client needs a power of attorney. It's just a form. But it's not just that, because what if you do just that, and then later on it's like, well, you represented them arguably for all their estate planning, and you didn't do X, Y, and Z, and now you're being sued later for it. So don't dabble in trust and estate planning. I think that's it. If we have some time for questions.
Thank you, Seth and Matt. Great presentation as always. I'll first ask,
thanks everyone. Sorry.
How is an engagement? No problem, Matt. How is an engagement letter different from a fee agreement?
Seth?
I can jump on that one. So, and I did see that there were questions that popped up throughout the presentation about engagement letters and retainer agreements and contracts for legal services. I mean, in my mind, it should be one document. This is one and the same. Your retainer agreement, whatever you want to call it, your retainer agreement, I call them engagement letters, they should include the entire scope of your contract, your payment terms, the parties' respective obligations, those clauses that we talked about earlier. That should all be in one document. So a short and sweet answer to that question is they're one and the same. It should be one document that covers everything.
Okay, great. Here's a good practical question. How do you recommend terminating the problem client?
Well, I mean, you have to. I think. Look, I mean, you don't want to do it in a way that would prejudice them, is what I would say. Especially if it's a matter in litigation. If the client's not paying you, for instance, or you you hit a point where, there's just irreconcilable differences between you and the client. I mean, do it in a way so that you're not putting them on blast with the court. First of all, you don't want to necessarily, do what you don't want to necessarily, clue your adversary in that your client's a jerk. Although you might not be able to prevent it. Be careful with what it is you file in court, with what it is you say about the client. Again, take the high road as much as you can. You don't want to be seen as abandoning the client or doing something that's going to prejudice them later. So that's the best advice I can give you is, do it, like, for instance, if there's trial coming up at the same time, you file to withdraw, ask for a continuance of the trial, just do whatever you can to make sure that client's interests are still protected, and that you're not creating exposure for yourself kind of on the way out the door, so to speak.
Yeah, good point. And then finally, can you clarify the risk with lateral hires? I know you touched on this a bit, Seth.
Sure. Yeah, I don't know why that risk is so much higher than for incumbent attorneys, but it is. And I don't have my notes in front of me, but I think it's about 8 times. You're 8 times more likely to be sued if you're in a lateral scenario. I have to think that the onboarding process is failing us, that we're not training and supervising and monitoring our new colleagues as well as those that have been around for a while. Maybe it's they're not comfortable with the conflict of interest policies. Maybe it is that they just practice law differently than we'd like. For whatever reason, it's a huge red flag, and it's something that we need to keep an eye on. And Matt and I talk about this internally at our firm about the importance of training and oversight of young lawyers. And the same is true with new lawyers. And a new lawyer can be someone who's practiced for 40 years, but if they're new to your firm, you need to pay special attention.
Okay, great.
There's really been, thanks everyone for joining us here. I mean, I think Seth too, I'd probably sit here and, field questions I think I got stuff I got to do, but I enjoy fielding the questions. There's a lot of good ones, that I see popping up in the box that, just we're not going to be able to get to all of them. And we apologize for that, and really, really appreciate you all joining us today. And thanks for all the positive feedback. Seeing a lot of, that's nice to see, that people like the presentation. So, cause we could sit here and talk about it for a long time. So thank you all very much.
Thanks, Matt. And that concludes today's event. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Seth and Matt. Thanks so much. Have a great day.